Good afternoon. My name is Lee Kin Ryan. Having looked at the case facts, I can conclude that there are a few viable claims that Monica can make against her employers, most of which would come under the Equality Act 2010. That act itself has a strict time limit of about 3 months in general before the last discriminatory incident. We see from the case facts that most of the incidents here happen within the month of December, so she should not face any time limit issues. Also, in Section 109 of the Equality Act, it states that anything done by any individual employee is considered to be done by the employer as a whole, with or without the knowledge of the other employees. The case of Miles against Jill Bank shows that both employers and any individual employee can be held liable in any potential claims. We see that in the characteristics of the workplace, Monica is the only Slovakian and white member of a team, while all the other members of a team are Somalian. In Section 4 of the Equality Act, it mentions that race and sex are protected characteristics, which means that any discrimination done based on those two characteristics would be liable under this subsection. And discrimination is defined in Section 13 of the Act, and it states that any person that discriminates against another because of a protected characteristics would mean that the person would treat the other person less favorably than how he would treat other people. In addition, we also know that from the case of Shamoon against Chief Constable of Royal Ulster Constabulary, it is held that in order to even establish any potential discriminatory claims, an actual comparator with the identical situation would be needed. And we have that because we learn from the case facts that because Monica was harassed and the rest of her team was not, and because of her unique characteristics, thus we can conclude that the company and Iftihar would thus be liable under these few subsections, and that Monica will be able to claim just with those few subsections. We then also learned that on 2 separate occasions, Iftihar, the supervisor, stood too close to Monica while giving instructions. This is even though she already made it clear to him that he was standing too close to her and that she feels he is violating her personal space. And then in another incident, we learned that the supervisor Iftihar allegedly stroked her hand while making remarks that her skin is so smooth and white. Both of these incidents we can classify under harassment. In Section 26 of the Equality Act, it defines harassment as engaging in unwanted conduct related to a relevant protected characteristics, and the conduct has the purpose of violating the other person's dignity or creating an intimidating and hostile environment. And the harassment would be sexual in nature if the conduct is sexual in nature. Thus, again, we see that the stroking of the hand and the standing too close would possibly come under these subsections, and that the company would be liable. Also, we learned that after Iftihar stroked Monica's hand, Monica told him off and ran away. Because of this, Iftihar the following day gave her a toothbrush to scrub toilets instead of a regular brush. This action alone would come under subsection 3C of Section 26 in the Equality Act. It states that subsection states that because of B's rejection of or submission to the conduct, A treats B less favorably than A would treat B if B had not rejected or submitted to the conduct. We can see from the case facts that again, Iftihar would be liable under this subsection. And then after that, we learned that a week before Christmas, Iftihar would send text messages to Monica encouraging her to go off with him and to spend time with him and also to have sex. Now this situation is interesting because it can be argued that this text exchange may take place outside working hours. However, the case of Jones against Tower Boot, the judgment shows that the course of employment can be applied purposively. This means that even though Iftihar may have sent these texts when the employers may be on, let's say, Christmas break, he can still be held liable for harassment. And then moving on from that, it is held by the courts, especially in the case of Reed and Bull information system against Stedman, that if the employer has reason to believe sexual harassment is taking place, they should investigate and take action if necessary. We know from the case facts that Monica complained on at least two occasions to a site supervisor named Vivian. Firstly, when Iftihar was standing too close to Monica, she complained to Vivian, and that Vivian promised her that she would look at the CCTV tape, but she didn't do so. And then when Iftihar stroked her hand and sent her those text messages, she again told Vivian about the incident, but Vivian did nothing and told her to get on with her job and that Iftihar meant no harm. Thus, based on precedent, the company would be liable under this action also. And also, Monica can sue under the implied term of mutual trust and confidence. Mutual trust and confidence means that the employer must not act without reasonable or proper cause and must not conduct himself in a manner likely to destroy or damage the relationship and the trust and confidence of the employees. Based on all the case facts given, it can be argued that any trust and confidence between the two parties have been completely destroyed. Again, another case that Monica may be able to rely upon is the decision in the case of Walker against Northumberland County Council, in which the courts held that the defendant, by doing nothing, by ignoring her, the company may be liable, and that they have breached their duty of care to respect the employees' health and safety. Thus, this means that Monica will be able to claim a few remedies. One of them is called declaration, in which the courts declare the rights of both parties, or she will also be liable for compensation. The compensation can include any award for injured feelings, and that the damages are based on the Vento bans, which are established in the case of Vento against Chief Constable of West Yorkshire Police, where the damages can be awarded based on 3 Vento bands of low, middle and top, based on the nature and the frequency of the discrimination. And lastly, the courts can also suggest an appropriate recommendation to the company. This means that the company has to adhere to the court's recommendations, or they may risk having to pay additional compensation. So to conclude, Monica has a few claims that she can make under the Equality Act 2010 based on how she was treated, and there are a few remedies available to her. Thank you.